Thanks everybody for coming. You have heard some long speeches on the floor of the United States Senate, so I will make my contribution today by being very short. And I'm especially pleased to have my colleagues here. Two members of the Intelligence Committee now are with you, an extremely important voice on the Senate Judiciary Committee, and an exceptionally influential voice for freedom and liberty in the Republican Party. That is, in effect, the coalition with you this afternoon. And we're here to unveil reforms to our nation's surveillance laws, reforms that, when enacted, are going to codify what Ben Franklin said years and years ago, and that is that security and liberty are inextricably linked. Today, we are introducing legislation that is the most comprehensive bipartisan intelligence reform proposal since the disclosures of last June. It is designed to set a high bar and serve as a measure for true intelligence reform. It expresses our bipartisan view of what Congress must do to enact real, not cosmetic, intelligence reform. The disclosures over the last 100 days have caused a sea change in the way the public views the surveillance system. It was obvious some time ago that when the American people found out what their government was actually doing, they were going to be shocked and they were going to be angry. Dozens of misleading public statements made by top intelligence officials have now damaged the credibility of the leadership of the intelligence community at home and abroad. Foreign governments and their citizens are finding their trust in the government to be compromised. This is not a small hiccup. It's an economic problem, and most importantly, it is a national security problem. When friendly governments begin to question their relationship with the American intelligence community, there are serious, serious national security implications. Our bill seeks to address the major cause of this damage and prove that our liberties and our security are not mutually exclusive. Let me just outline a few key provisions. First, we outlaw the bulk collection of the records of millions of law-abiding Americans. The bulk email and phone records programs have not provided unique value beyond what can be obtained from existing intelligence collection authorities. In fact, the email collection program was ended 2 years ago because it was ineffective, a cause that Senator Udall and I spent a lot of time focused on. This legislation allows the government to obtain the records of people connected to terrorism or espionage, but the dragnet collection of communications of law-abiding Americans ends with this bill. Second, we close the backdoor search loophole found in the FISA Amendments Act that gives the government the ability to search for Americans, law-abiding Americans' communications without a warrant. The law was intended to collect communications of foreigners, but tens of thousands of wholly domestic communications have been collected as well, and there is nothing in the law that requires the intelligence community to get a warrant before searching for Americans' communications in that pile. The backdoor searches loophole was originally closed in the 2008 reauthorization of FISA, but it was reopened when that bill was again reauthorized in 2011. Our bill closes tight this backdoor search loophole. We overhaul the Foreign Intelligence Surveillance Court, which is arguably the most bizarre court in America. Here we've taken the lead of Senator Blumenthal. He proposed recently to install a constitutional advocate to argue against the government's position in cases related to important constitutional liberties. So, for example, Senator Blumenthal made the point that if you look at Section 215 of the Patriot Act, where the FISA court expanded the definition of relevance to the point where they could collect millions of phone records, Senator Blumenthal would essentially give us the idea that there would be somebody there to argue the other side. That's high time, and he's got a good idea, and it's in this bill. Finally, a especially important contribution was made by Senator Paul. It, as usual, comes from conversations that the two of us have had on these freedom issues, and we have included an expanded ability for Americans to fight surveillance laws in court. This is consistent with what several Supreme Court judges have said, And with our bill, including the Paul provision, it's going to be easier for those who've had their careers and businesses damaged by the government's overreaching in intelligence collection to challenge the constitutionality of government action. This principle, as I've noted, has been upheld by some judges, but it ought to be codified into law. Last point is we take steps to improve transparency, protect the abuse of national security letters, and strengthen prohibitions on reverse targeting. And at the end of the day, this bill addresses an issue where there has been historical change. Historically, the limits of technology served as a strong check on the abilities of the government to do surveillance. Today, with technologies that make surveillance almost omnipresent, the key to preserving liberty and security is to embed new legal protections for law-abiding Americans into the law. That's what our bill is all about. Senator Udall, Senator Paul, Senator Blumenthal all make short statements. Softball questions then for me, difficult ones for my colleagues, and Senator Udall from Intelligence Committee.
Thank you, Senator Wyden. I don't have to tell all of you that there's a growing bipartisan sentiment in Colorado and all across our country that the balance between Americans' privacy and security is fundamentally out of whack. And the significant reforms in this bill are especially important in light of recent declassified reports that show what Senator Wyden and I have known for years. And that is that the NSA, the National Security Agency, has been unable to properly manage existing surveillance programs. This has led to the abuse of Americans' privacy and misleading statements made to the Foreign Intelligence Surveillance Court. And we've only seen the tip of the iceberg. So as Senator Wyden laid out, we are here today to unveil a comprehensive surveillance reform package. This package includes ending the bulk collection of millions of Americans' phone records, prohibiting the backdoor searches of Americans' communications, and making the Foreign Intelligence Surveillance Court more transparent and accountable. These are common sense reforms that will keep our country safe while still protecting our constitutional rights. Senator Wyden and I serve on the Senate Select Committee on Intelligence, and for over 2 years we have been leading the effort to reform these programs, even when they were highly classified. Now that more details of these programs and their legal justifications have emerged, we're seeing a growing consensus among the American people that the status quo is unacceptable, and we agree. And these aren't vague or abstract threats to our liberty. These kinds of things are happening right now as we speak. Right now, innocent people all over Colorado, all over our country, are among the millions of Americans who are having their private records collected under these programs. That's why we're calling on the President and Congress to end the bulk records collection program. And that's why today we're taking the next step in making that a reality. The support for this reform has been bipartisan, it's bicameral, and I can't tell you how many times Coloradans, and I think my colleagues here would share their stories, come up to me on the street and the grocery stores all across the state of Colorado to tell me that they may not agree with me on everything, but they want me to keep fighting like hell to protect our constitutional rights to privacy. These are common sense reforms, and they're part of a comprehensive plan to reform these broad surveillance powers in a way that strengthens our privacy rights and protects our national security. And I want to emphasize that. Under this bill, the federal government will still be able to get hold of terrorists and spies' phone records, but only where the government can demonstrate a suspected link to terrorism or espionage. And although I strongly believe that some surveillance programs have made us safer, Americans with no link to terrorism or espionage should not have to worry that the NSA is vacuuming up their private information. Our critics say we cannot protect both safety and privacy, but that is a false choice. What we are proposing today are sensible reforms that tighten surveillance authorities and add transparency so that the American people know how their laws are being interpreted behind closed doors. Senator Wyden, I'll kick it back to you. And should I just take Senator Paul?
Senator Paul. The gentleman, Senator Paul.
Yeah, go ahead.
Colleague from Kentucky, Senator Paul.
You know, the Fourth Amendment says that you have to name the person and the places. I just don't see how we can reconcile that with a warrant that has 10 million unnamed people in it, all customers of Verizon. I just don't know how that can be consistent with the Fourth Amendment. But when this decision comes from a secret court, how do we challenge the constitutionality of that? I think the constitutional advocate will be very important, but I think it also has to be very important that the constitutional advocate, if he challenges the constitutionality of this at the FISA court level, it has to go to an open court. You cannot have the constitutionality of our law interpreted in secret. We have to have it go to an open court. And so my hope is with this legislation, we will allow things to go from FISA. And I don't mind if names are redacted. We don't need terrorist names in there. But the concept, that's not a secret concept of whether one warrant can name 10 million, unnamed 10 million people and apply it. To me, that's a general warrant. That's not a secret. That's a constitutional question. That's something we can debate and discuss in the open. We have this cloak of secrecy. Some of it needs to be there for protecting individual names and places and people. But the idea of whether we're spying on Americans without warrants is a debate we should have in public at the Supreme Court. I wholeheartedly support this effort, and I hope we're successful.
Thank you. Thank you to my colleagues, particularly to Senator Udall, Senator Wyden, for being longtime champions of constitutional rights and liberties in this area of intelligence and surveillance. And thank you to Senator Paul for being a ceaseless voice on behalf of protecting the Constitution. And these reforms are the right thing to do, but they are also essential to the public believing that the system is complying with the law. Trust and confidence are the lifeblood of this surveillance program and from achieving the national security objectives that are essential to this program. Far from being inconsistent, national security and constitutional liberties are actually mutually supportive. They are essential to each other. The whole reason for having this national security program is to protect our constitutional liberties, and the secrecy of this program is undermined if people lack trust and confidence. So this court has really been in need of reform for a long time. Its rulings and opinions need to be made public for public trust and confidence to exist. And there needs to be a constitutional advocate to make sure that the process is adversarial like every other court in the United States of America. You know, when you think about it, secret courts were one of the reasons that we rebelled as a nation against the English. Star chambers became a symbol of our reason for revolution. And secrecy should be really an anathema to our judicial process, and certainly where secrecy is accompanied by only the government being heard, it can lead to abuse. And anybody who has any question about whether abuse has occurred ought to read Judge Walton's opinion, when clearly the government acted, in fact, was found to mislead and misrepresent to the court. To answer some of the concerns, there should be no delay from the fact of a constitutional advocate, because the review can be of the warrants after they are issued and implemented while they are ongoing, so that there's no threat to national security, nor is there any threat for an appeal. As Senator Paul said, that appeal can be to the United States Supreme Court, it can be to the courts of appeals, it can be to the FISA courts of review. The appeal right now is non-existent because only the government is represented. This constitutional advocate would have as its client the rights and liberties of U.S. citizens, and it would be an aggressive advocate for the constitutional liberties that we hold dear and need an advocate in this court.
Sounds too logical for some, but this is what the four of us are going to pursue.
Do any of you think that Clapper or Alexander should resign, or anybody else at the senior level in the administration? I mean, the last time Clapper testified before the Senate Intelligence Committee, he gave what he admitted was an untruthful answer. And also, Senator Wyden and Udall, you two have talked about the idea that this is only the tip of the iceberg, what we know. What's what more is there? What do we not know?
Let me let my colleagues weigh in first, and then I'll go last. Rand, you want to start that? You and Ted strong.
You know, I may have a difference of opinion. I think Clapper really I think in order to get back credibility for our intelligence gathering, that Clapper should resign. And I've said that repeatedly because I don't think you can come to a committee and lie to a committee and expect to have credibility. That's not all of our positions, but that's mine.
Let me say this. The intelligence community is composed of patriots. It's composed of people who work 24/7, 365 to keep us safe. They've had many successes. The reason that this reform package is so important, though, is that we need to direct the intelligence community to conduct their activities in a fashion different from how they've been conducting them in some of these areas over the last 10 years. Senator Wyden talked about how technology's changed dramatically, and that's the case. It's changing the way in which we live our lives across our society. But the need for stronger, more clear laws has never been more obvious. Senator Blumenthal put it well as well. He pointed out that the more transparency there is, the more secure we are because there's a greater faith in the part of the American people that the Bill of Rights is being respected. The Fourth Amendment was put in place for a reason. The king could not only take your property and your treasure and your life, but maybe even more precious, your freedom. And that's why it's so important to not only defend the Fourth Amendment, but make sure that it's being utilized and applied in ways that respond to the 21st century threats that we face. Bulk collection through the 215 program ought to end. It didn't work for email collection. It's not working for phone collection. There are a lot of misunderstandings out there about the way in which the 215 program works. It has never been proven to Senator Wyden or me that any of the bulk collection has provided uniquely valuable intelligence that's resulted in the disruption of any plots. You hear the number 54 plots being disrupted and on. That does not stand up to scrutiny. If any of those plots have been disrupted, it's through the 702 program, which legitimately surveils foreign terrorists and foreign actors. That is one of the key things that we're going to do with this piece of legislation. I get a little far afield from your question, but I want to make those additional points.
Yeah, let me just say very quickly, this bill is not about any single individual or any group of individuals. It is about much larger issues. The bill is larger in its purpose than any particular individual official. It's about the rule of law and how to protect individual rights and liberties regardless of who is in office. And I just want to emphasize the point that was made. You know, these men and women in the intelligence community are dedicated, brave. They need to be given a legal framework that is worthy of their courageous efforts.
Let me just add one other point to that is, notwithstanding the exceptional work that thousands of patriotic members of the intelligence community do day in and day out, the American people deserve better than to have the Director of National Intelligence and the head of the NSA make statements that are intentionally misleading. Now, Congress people do not have the authority to go off and make various decisions. I often get asked about this. So our focus, as Senator Blumenthal and Senator Udall and Senator Paul and I have all talked about, our focus is to change the laws that make these practices possible. That's why we're here. That's why the bill's going in tonight.
Have you had any discussions with colleagues in the House about this? Do you have a sense of what support they might have there?
Go ahead.
The answer is yes, and clearly the Amish Amendment right before the summer break was a huge wake-up call in terms of how this debate has changed. I can tell you that if you had said to the three of us and Senator Paul that you'd have a vote on the floor of the House of Representatives where 200 or so House members voted for fundamental, reform, first of all, you wouldn't even had a vote. You wouldn't have had a debate. It wouldn't have been out there. So that's why we think that this is a unique time in our constitutional history, and we are determined to fix it. And we've had discussions certainly bicameral discussions all through the summer.
Senator, with the limited amount of time left this year, what are the prospects for the Senate doing this bill in the remaining weeks?
Let my colleagues
We
go
have a
first.
number of fronts on which we're going to operate and quite frankly, I think fight, because this is not going to be easy. We're going to take this up in the Intelligence Committee. We're going to have an open hearing tomorrow when we mark up proposed reforms has yet to be seen, but there are some commitments that it would be done in the near term. Judiciary Committee, under the able leadership of Senator Leahy, will also take up a set of reforms, and I anticipate in the House the same thing will begin to build. And what you see in this effort is unlike a lot of what's happening in this particular Congress, which is that you have bicameral, bipartisan interest and support. And we don't have enough of that in some other areas that I care deeply about: energy policy, budget policy, and immigration policy. But I think you're going to see a very robust debate. American public is waiting for us to act. It's time to act. I'll turn it to.
Yeah, I think we're going to.
On the defense authorization bill?
That's always a nice vehicle.
Having talked to some of my colleagues in the Judiciary Committee, I'm on the Armed Services Committee. We're going to have a lot of debates, as we did last time around, dealing with a number of these issues when the National Defense Authorization Bill is considered on the floor, which will be certainly this year. But our colleagues on the Judiciary Committee in the House are very interested. I've talked to members of the Intelligence Committee who are receptive. There are a number of different vehicles to move it forward, but most fundamentally and importantly, what you see here and in the debate on the floor already is a coming together of very diverse ideological elements of our respective parties. It's not only bipartisan, it is very much a coming together of disparate and very different ideological strains of both parties. And you can see that geographically as well as politically. The interest here is one that unites a lot of people who may have very little else in common.
I can tell you, I believe we have exceptional momentum right now. And if you had told me 6 months ago that somebody would come up to me in the barber shop and ask me about the FISA court, I would have said, right. And what also is driving this reform effort is the synergy between those off Capitol Hill and on Capitol Hill. For example, a big victory for us recently was the Electronic Frontier Foundation lawsuit that exposed the thousands and thousands of violations of the privacy rights of the American people. The reason that they were able to file that suit is we were able to finally get declassified the finding that the FISA court had said the Fourth Amendment had been violated in the past. Once we got that declassified, and the Electronic Frontier Foundation noted this in their statements, they were able to go to court and sue to get all the relevant documents. And I think it's that kind of synergy between reformers on and off Capitol Hill that is new. And I can just tell you, it was a real lonely cause here, 6, 7, years ago. And finally, we got some wonderful reinforcements, to the Senate, Senator Blumenthal, and the Judiciary Committee. Senator Udall joined the Intelligence Committee, and our side was no longer meeting in a phone booth. So I think we've got exceptional momentum now, and this is a unique time in our constitutional history, and I just feel so fortunate to have this kind of group pursuing it, because I think we can get this done. And what we did today is our analysis of where the bar ought to be set for intelligence reform. We're going to try to measure intelligence reform as it relates to what the four of us on a bipartisan basis think constitutes real reform, and not some sort of cosmetic reform where you just take the old wine and put it in a new bottle.
Senator, can I ask, the public advocate, in your vision of how that would work,
the constitutional advocate, we're calling it a constitutional advocate, you know, let me make clear, first of all, would require very, very minimal funding. We're talking about a very small group, but it would be funded in the same way that the FISA court is. It would be essentially administratively a part of the FISA court. It would be funded from the same allocation that the FISA court is, and the courts in general.
How would it be chosen? I'm not thinking so much about dollar amount, I'm thinking more in terms of independence.
Well, the constitutional advocate would be appointed by the Chief Justice of the United States. So he or she would be independent in terms of appointment. And second, in terms of the independence, and I understand and appreciate your question, that person, that office would be everybody as independent as the court itself.
Yeah, and Senator Wyden and I were just discussing the question, $80 billion in the intelligence communities.
I think I was just talking to you know, the staff. The intelligence budget and the court budget is separate, but the basic point that my colleagues are making is that this is for policy questions. These are for major questions. They're not going to be involved in every single kind of warrant issue. The example, the example that we hear continually is when the court was looking at the relevance definition in 215, the Patriot Act, a hugely consequential decision, and took those plain words of relevance and let it morph into collecting the phone records of millions of law-abiding Americans. There wasn't anybody there to argue the other side. That's a policy question. So this is not imagined to bring thousands and thousands of cases.
As I said, my concern isn't with the dollar amount. The big criticism of this court has been, since every judge is appointed by the Chief Justice of the United States, if the public advocate is also appointed by the same person, how independent an advocate, how would you guarantee that the person was for your?
Well, I have a proposal to change the appointment method, and that might well be part of this kind of reform, which would be, instead of the Chief Justice acting alone, as he does now, to do all of the 11 appointments, the Chief Judge of each circuit, there are 13 circuits, would designate someone who then would be appointed by the Chief Justice. So we changed the method of appointment. Your question's well taken. How do you assure the court is more independent or diverse ideologically and geographically? That's a concern, but that is separate and apart from the funding issue.
Oh, yeah.
The independence of the constitutional advocate has to be assured, just as the independence of the court has to be assured.
Why don't we take a couple of others and we'll wrap up.
What's the White House's response been so far to your principles and proposals?
I'm very, very hopeful that they will see the combination of bipartisanship here. We've certainly alerted them to all of these issues. Senator Udall and I met with the president in a group on August 1st before the break. We talked specifically. We'll always talk about what we said, not what the president said, but we talked about eliminating the bulk phone record collection on law-abiding Americans. We talked specifically about the backdoor search loophole. A number of us, I remember mentioning Senator Blumenthal's proposal for the independent advocate. I think that they understand now that the American people recognize that liberty and security are not mutually exclusive. So I'm very hopeful, given the fact that this is an effort to, in a bipartisan way, flesh out some of the ideas we've already talked about, that they'll be supportive.
Yeah, I think if I could make one further comment on that in that regard. We're going to continue to make the case, and you all can help us, that there have been misleading statements. There has been a conflating of 702 and 215 and the effectiveness of those programs. And when the American people understand that 215, the bulk records collection, that resulted in millions of phone records being collected every day, that it has not provided uniquely valuable intelligence and in fact has violated Americans' privacy. That case alone has got the administration's attention. The president spent a lot of time discussing that particular situation with us when we were with him. One other comment I want to make is, and Senator Wyden alluded to this, is economically what's been happening is having an effect. You talk to our service providers, you talk to the content providers. They're beginning to find that in doing overseas business, which is a significant portion of what they do, the foreign governments are not particularly inclined to believe what they're saying, nor to do business with them going forward. So this has had an economic effect as well as a security effect. And for that reason alone, we needed to put these reforms in place.
Let me just respond directly on the constitutional advocate proposal. I think the president has virtually endorsed it, although not using that term and not describing it in any detail. In fact, in a press conference that he had, I recall that it was late on a Friday afternoon, we can get you the exact date, he specifically discussed this idea, as would be expectable because the president, being a lawyer, knows that courts function best when they hear both sides of the argument, not when they go by one side alone. So I'm very optimistic about the administration approving and supporting that idea, and I think, you know, they want to preserve and enhance this entire program, and my expectation is they'll consider carefully all of these proposals.
Can I just
We'll take one last one.
Can I just clarify that Senator Feinstein and Chambliss are doing something different, correct? I mean, you seem to say that you would expect your bill to be taken up by the Senate Intelligence Committee, but,
Well,
but they're doing their own
let's
vote, right?
let them speak for themselves. One of the reasons we wanted to move today is that tomorrow starts the public hearings on intelligence reform. The Intelligence Committee will be holding the first tomorrow afternoon. The Judiciary Committee has already announced it. There are discussions of various senators introducing legislation. We're not announcing that somebody has scheduled a markup date for such and such date, but it's very clear that now the debate has begun, and we wanted to start the debate this afternoon by offering a actual piece of bipartisan legislation. In other words, we'll have this for you. You all can, look at it. It's going in, later today. It addresses a number of issues that we've talked about at length in the past. Senator Blumenthal mentioned the White House has, all but endorsed the concept of his, and we talked about a number of these other issues. And I think with 3 or 4 Supreme Court justices picking up on the message about expanded standing, we'll be well positioned with respect to those issues. But until you have an actual piece of legislation and that colleagues can review, you really don't launch the debate. So that's what we're doing today. We're launching the debate with an actual, bill setting the bar that we think is the real measure of intelligence reform, and we'll stick around and visit with you.
Thank you all.
Thanks, everybody.
Great job.
Good job.